Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business. We've designed this TV show to educate you in simple to understand plain English ways for complex legal terms, to help you understand why you undertake certain legal aspects of your business, and to help you develop a plan for the future success of your business. Did you know that any business owner is on average 7 months away from losing everything? And that is the average time that it takes for a successful business to fold when an aspect of their business is not set up correctly. Have you ever wanted to get legal advice but didn't understand what was going on? And do you feel like there's a divide between lawyers and their clients? If that's so, then this TV show is for you. We've designed the show to empower you and your business with the knowledge and tools to help ensure that those problems that so many businesses encounter don't happen to you. Business Legal Lifecycle TV delivers a twice-weekly show focusing on the legal aspects of your business. At lunchtime on Mondays, we present Fast Fix Monday, a quick 5 to 10 minute show to give you some actionable steps to consider for this week in your business. And at lunchtime on Wednesdays, we present our in-depth show. It's generally between 30 minutes to an hour to go through the complicated legal aspects of your business in a simple to understand and plain English way. That can be through educational pieces or interviews with experts in the fields. We welcome you to Business Legal Lifecycle TV, and here's our show.
Welcome everyone to this Wednesday edition of Business Legal Lifecycle TV. I'm Jeremy Stretton.
Hi everyone, I'm Craig Mason.
And today we're finishing off phase 5 of the Business Legal Lifecycle. So September 2017, if you're watching this on the replay, has been all about intellectual property. And today we thought we'd round it out by having a bit of a chat around patents and other forms of intellectual property. So if you've been watching the shows this month, we've talked about trademarks, we've talked about systems, and we've done a little bit on patents. But today we thought we'd go into a little bit more detail about patents and the patent process, as well as we're going to talk about registered designs, we're going to talk about circuit designs, and we're going to talk about plant breeders' rights. Welcome. And Craig, anything else to add before I flick over to the slides?
No, I don't think so. Let's do it. We're starting off with patents, yeah?
Excellent, yeah. So let me just click this across. All right, so patents are a form of intellectual property that is used to basically protect an idea that's innovative. So the idea is if you have an invention that's a device, a substance, a method, or a process that's unique, then you can apply to get a patent registered over that invention. Now, they're interesting things because there's actually 2 types of patents in Australia. There's a state standard patent which lasts for 20 years, and then there's an innovation patent that lasts for 8 years. And for anyone who's watching in the pharmaceutical game, there are also pharmaceutical patents that last for 25 years. But I'm not going to talk about those in any details because I don't think any of our viewers are probably in the pharmaceutical industry. If you are interested in knowing more, then please let us know. A standard patent is really a protection that gives you a monopoly over an invention for 20 years and can be extended in certain circumstances, not a lot. Basically, when you claim a standard patent, it's got to be a new inventive or a new and inventive involved step in a process. Now, there are many technical requirements for a patent. As you can imagine, if you're receiving a monopoly over using a process or an idea for a long period of time, 20 years, which is a long period of time, it needs to be inventive and it needs to be something that people will actually need to use in the future. Now, the other type of patents are innovation patents. So an innovation patent is one that it's a little bit easier to get. Basically what you're doing is you're getting a new idea. So a lot of software ideas are innovation patents. And you only get that protection for 8 years. But what you do is you protect the new device, substance, method, or process for that period of time. And because it's only lasts for 8 years, the process, which I'll go through in a minute, is not as in-depth. So patents, as I say, they are interesting beasts. One word of caution though, what a patent does is it does restrict innovation on your product. So if you've come up with a new interesting idea, let's use 3D printers as an example. So 3D printers were developed probably 25 to 30 years ago. They were invented by some of the big corporations in the US, but they quickly patented the technology that allowed them to 3D print. Now what that meant was that they actually restricted other businesses from being able to use and innovate on those products. Now, in the last probably 2 to 5 years, we've noticed that, or if you've looked at it at all, you would have noticed that 3D printers are becoming more in vogue, and they're slowly developing bigger and better products through the innovation space. The reason for that is that the main patent on a 3D printer has actually been wound back, and now they no longer have that protection, the people who invented it. So what that's allowing is people to innovate. Now, throughout the 3D printing process and over the last 20 odd years, the way that you do the 3D printing has evolved, and each evolution, people have got more patents. So it's going to take a little bit of time for that to be open, but you need to be careful if you're applying for a patent that you're not just applying it for the sake of it, and that you're actually making sure that you get what you're actually trying to protect, and you're not stifling innovation. It's a mix. It's a mix that you need to get right. And look, there's no right answer. There's always many ways to be right in all these things, but you need to be careful that what you're doing is actually not going to cause any problems for future innovation on your product. So one of the big tips with a patent is not to go to the public too soon. Now, the reason for that is that as soon as you go public, and if you do that before you have a patent in place, you'll actually probably stop yourself from able to get a registered patent. And that's because the new idea has to be unique. It has to be something that people haven't thought of before, and that isn't in the marketplace. So be careful that if you do want to go and register a patent, that you make sure you do that early on. Now, some of the benefits of a patent, I think it's important to think about these things. Basically, a patent will give you the right to stop others from manufacturing, using, or selling your invention in Australia, if you've got it registered in Australia, without your permission. So what that allows you to do is actually to go and license the use of that patent to other business owners. But often people don't want to do that because they've actually, they've put the time and effort into their patent, and they want to protect that. So it also encourages you as the patent holder to continue to research and develop the new and innovative products. That did happen with the 3D printing example that I gave before, but what it did stop was other people from innovating on those products. So you've got to be, as I said before, it is a mix and something that you've got to be very careful on, because you want to be able to exploit your invention. Patents were brought in to allow people to invent new things and to be able to protect those inventions. So you've got to see what it's actually going to give you and whether it's worthwhile. The other thing that it can do is it can actually help you with trading partners. So if you've got a trading partner and you want to incentivize them to provide you with rights to use their products and export overseas, then a patent can be a great way of protecting your intellectual property and giving you something that you can actually negotiate with them. So in deciding whether or not a patent is the right choice for you, well, there's quite a few different things you need to look at. The first thing is to determine whether or not what you've invented is actually patentable. And that's not an easy process. It's not something that I've done a lot of work on, but I do know from dealing with patent attorneys and other clients of mine who've gone through the process that there's a big register, a database of patents out there, and you need to make sure that what you're doing is actually unique, because the process does involve, and I'll go through the process in a minute, but the process involves quite a bit of time, quite a bit of effort, and it isn't cheap. So not only have you got application fees, but you've got fees with your patent attorney to make sure that it's drafted correctly, and also to maintain the patent for the period of time. There are fees that you want to actually have to put in there. The patent also gives you the monopoly over the patent, and that lessens the risk of people stealing your intellectual property. And so that's a great protection for you. And it also allows you the resources to manage your intellectual property. So one of the keys to this is to do a thorough search of the databases. So I've mentioned before, and the focus of today's show is about Australian law, but there are patents in other countries. It's a lot easier, for instance, to get a patent in the US, and it's similarly as difficult in the UK to get a patent. But what you want to do is do a thorough search of all those databases to make sure that what you're going to get a patent over can actually be protected. Once you apply to register your patent, that information becomes publicly known, and so you want to make sure that you've got it done properly before you actually go ahead. But once you get a patent, and if this is important to you, you own that invention, and you're able to exploit that moving forward. So, a lot of people use patents where they're doing new and innovative ideas for their business. For science and technology is a massive area where they do that. So, you need to think about that carefully. Now, the next question is who can actually apply for a patent? Well, the simple answer to that is the person who makes the invention. So if you invent something that's new and innovative, then you can apply to have a patent. You can also apply if you buy the rights to that intellectual property. Now that's a bit harder, and in the past Craig and I have done a show on patent trolls. That's what patent trolls do. They acquire an invention, and then but usually they acquire it after the patent's been granted. But you can actually buy a patent from someone who's invented a business or a product or an invention, and you can actually make sure that it can be protected. The other, obviously, any entity can apply for a patent. That can be a company, an organisation. If your employees come up with an idea, depending on their and depending on the terms of their employment contract, and whether or not it's in the ordinary course of their normal duties within the business, then you can actually apply for a patent for your employees. So that's something that we haven't had the pleasure of doing yet, but I'm sure that that's something that a lot of businesses can do. And if you are in the business of inventing stuff in your business that might be innovative, then you should think about what protections you need to put in place with your employees. So if you decide that not to patent, I think that's also another important thing, that you may decide that you don't want to actually patent your product. As I said, it is a costly, time-consuming, and can be a bit of a stressful process. What you invent might be a trade secret, and so you might have some common law rights to protect it. So you don't have to apply for a trademark to protect what you've invented. But a trademark is a registered device that lets you actually enforce through the Patents Act and stop other people from using it. So if you do come up with an invention that falls within what we call a trade secret, so that's a new and inventive idea that you can protect through that process, then you don't have to register for a trademark, but it might just become a lot harder for you to register it. So the next slide that I wanted to click over to, so I'll just click that over, is the process. So the process and the time for applying for a patent is pretty important to understand, and I've kind of alluded to this in the process. So the first thing that you need to do as that process is to go and speak to a patent attorney. A patent attorney will be able to do the searches and to give you the right advice as to what else exists that might challenge your patent or might stop you from having it invented. The patent process involves you breaking down your patent and your invention into a number of little steps. And there's a certain formula that you have to do that with to apply for the patent. And so patent attorneys are the best people to do it. If you try and do it yourself, what you're going to find is that you're going to struggle because you're really not going to understand what's going on. And when you apply for a patent, you've got to pay a fee, obviously. They don't want, the IP Australia, who's the government body that regulates all this stuff, doesn't want people just applying for patents willy-nilly. And that depends, and I'm not going to go through the fees, but there are fees that are involved. Then it goes through an examination process. So this is where a IP examiner and a patent examiner will actually go through what you've submitted. They'll go through the invention, the step-by-step guide, and they'll look at whether or not it actually is new and inventive, whether there's anything that's closely related to it. And often, and probably more often than not, they'll actually come back to you with questions and require you to refine your design. It's very rare, I don't know from talking to patent attorneys, that it's very rare that a patent will actually get registered first up. That just doesn't happen. There's usually questions and processes that need to go through. So once they go through that process, then you can be granted a patent. And there are some other little processes on the way, but I'm not going to go through those in any depth in today's show, because you actually need to understand that process and go and get that advice if you're going to go and apply for a patent. So once you get a patent, as I said before, a patent can last up to 25 years. Now, there are fees, and I will just mention these, there are fees that you have to pay to continue the patent. Now, the reason that the government has introduced those fees is to protect consumers and to not just let you have a patent that lasts for 20 years without you actually using it or having to provide some benefit to the government and some pain for yourself. So there's a fee. The patent will last for the first 4 years. Then the 4th anniversary to the 9th anniversary is a fee that you pay for that. And at the time of recording, that's $300. From the 10th to the 14th years, there's another fee of $550. From the 15th to the 19th year, that fee is $1,250. And if you are a pharmaceutical company, then it's another $2,500 to maintain that over another 5 years after the 20th year anniversary. If you've got an innovation patent, which I mentioned before, which has a lesser threshold for registration, then there are fees to continue that patent for the 2nd to 4th anniversaries. It's only $110. The 5th to 7th anniversary, and that's $220. Now, I raise those because one of the things that I've found with people with patents especially is that you move around. People don't often stay in the same house or the same business address for very often. And so what's important is that you make sure that you keep your address for service updated with IP Australia, because they send out notices. If you don't receive the notice, then guess what? You don't get to have the renewal, and you'll probably miss out. Now, there are late fees that you can pay for certain periods of time, but I think probably the biggest tip I can give you coming off the back of the process is that the address of service should be your patent attorney or your registered office, and you should make sure that you know where that is, especially if you're a person who has, some people have hundreds of patents. Well, you want to make sure that your address for service for those patents is consistent, so that you know where the patent is and where it changes. So that's what I was going to go through today with patents. I don't seem to have any questions. So, Craig, if you don't have anything to add on patents, then why don't we flick through onto registered designs?
Yep, excellent. As Jeremy said, with patents and even with designs, registering these sorts of things, seek the advice, talk to the people that specialise in these sorts of areas, get all your consultants together, because it's obviously an important step that you're undertaking. And as Jeremy said, the time spent and the costs involved can be high. So you want to get the consultants involved so you get it all done properly and you don't have to get extensions and various other things. So as we always say in the business legal life cycle, getting the right sort of team of advisors and consultants around you is an excellent way of making sure your business is successful. So so with design, so that's what makes a product look the way it does. So that includes the shape or the configuration or the particular pattern. When that's applied to a product, it gives it a unique appearance. All of these things from a design point of view are governed by their own act, and that's called the very original Designs Act 2003. So that's one of the intellectual property acts that governs these sorts of things. So obviously the whole process of registering it, the aim of it is to protect that particular design and allows you to use it commercially, to license it, or to obviously to sell it. So some designs obviously can't be registered. One of them is Australian currency. Obviously, you can't go and make your own currency and design that and get that registered. Obvious reasons, it's pretty straightforward. Integrated circuit designs are separate to this, and I'll talk about that in a little while. Something like artwork, that's protected under copyright, but if you use that artwork into a product, then that's when it gives it a unique look, and that could be a design that could be registered. So going back to the time and the costs involved, obviously you're going to have some specialists that are going to go through this with you, and you've got your designers, those sorts of things, lawyers. You might need a patent attorney as well, depending on what it is. and to go through all these sorts of things. It does take time, and there are going to be costs involved. So the actual costs leading up to the registration process are probably going to be the highest ones. The costs for registering it and making the application Type E Australia, aren't that expensive. But the fees that you're going to pay your consultants is where it's going to add up. So you want to get the right ones. You want to get it done properly the first time, so you don't have to do it again. There's all sorts of extensions and renewals and those sorts of things, which I'll go through in a second. So with the registration, so you can register your design, and that gives you 5 years from the date that you filed it, and that can be renewed for another 5 years. But that's 10 years is the max for the registration on that. If you want to, you can also get it certified or issued with a certification. And that means that the IP Australia or some design person, third party, examines your actual design, and then they can give it certification. And that means that you've got a legally enforceable design, and you can take action on those sorts of things. But to be certified, there's a process, examination, and it has to be a new and distinctive design in order to get through that process. So you can get it registered for 5 years, but if you want to take that extra step, you've got to ask for it to be examined and you get what's called certification. And so the difference is that you've got the exclusive rights over that design when it's certified. So obviously, before you go through all these things, you've got to decide if you've actually got a design that you're entitled to, that you're the owner of the design. So, back to the employees and those sorts of things as well, you need to look at that. And you can apply jointly for this as well if there's two parties that might have the same rights to it. You need to do your searches and make sure that it's not already out there, searching the IP website, those sorts of things. Same with patents. Don't go publicising your design, because once it's out there, then you've obviously about it's already in the public domain and whatever else. So don't do that. Then you've got to prepare all the drawings of the design. So it's not as simple as doing a quick scribble and attaching it to your application and sending it off and going, yep, giddy up, we'll get our... There's a process where for the drawings, and I don't profess to be anywhere near much knowledge in terms of what the drawings are, but you've got 3D and different angles and those sorts of things. So you've got to go through the process of getting a designer to do up all the drawings to be lodged. In terms of the timing of all this and how long it takes, it's normally about 3 months from the application date as to when you're probably going to get an answer. And the costs are, it's about, depending on how you do it, it's about $250 to $350. Renewals are about $300 odd. And if you want to do the certification, the examination process, again, depending on who you get to do it, it ranges from about $210 to $420 for the fees for IP Australia. With the examination, that normally takes 3 months on top of the original 3 months. And then there are, if it's knocked back for some reason, then there are ways of responding and disputing why it's been knocked back, and they give you a time frame for that, which can be sort of 3 to 6 months. So it's not a quick process by any stretch of the imagination. And you've got your consultants that'll run you through the timings and all those sorts of things. But yeah, it can take quite some time. You're looking probably 6 to 12 months, I would say, for most of them, I would have thought, depending on what stage you are at in terms of having your drawings and those sorts of things ready to go. But if you've got all that information, then you can sort of restrict the time frame down if possible. So that's designs, Jeremy. If you flick us over to the next slide about circuits.
Done.
Yep. So circuit designs are different or apply differently in this space. So they're protected by essentially copyright. So your circuit designs are, your computer chips and those sorts of things, which are in, most things these days. So they have a separate structure. So it's not through this process. It's through copyright, which we've spoken about over the last month, doing the episodes about different types of intellectual property. And one of those is copyright. So as I said before, protection for artwork and those sorts of things is copyright. And same with the circuit designs are then protected by copyright, so they're not going through the same process of a design, which I've just spoken about in terms of the product that gives it a unique appearance. So that's circuit designs. And now, Jeremy, if we go on to the last one, the last sort of intellectual property thing that we want to speak about today.
Yep.
For all you plant experts out there, Jeremy.
Done. Yep, ready to go.
Yep. Oh, you got plant breeders' rights up there?
Yep.
Okay. So that's, if you're breeding plants, so if you're, commingling and taking off various things for making a unique plant. So there's a process there where you need to go through that as well. Again, this is not an area where you just go out and do it and don't talk to your advisors about it first. So it's only new or recently exploited varieties of the plant that can be registered. So, you're going to have your experts involved in this. Again, we don't profess to be botanical experts, so you'd get, qualified people to get involved with that process. But it's something that does exist, and it seems like would be a small sort of area, but it's got its own sort of structure in terms of going through this and searching to make sure that it doesn't already exist and those sorts of things. So it's one area that we won't spend too much time on, but we're just touching on it today as sort of the smaller sort of intellectual property that might apply to a particular business that's in that area. But again, we can't stress enough that seeking advice from your consultants on these sorts of things is very important when it comes to this. So that's plant breeder rights.
Excellent. Well, thanks, Craig. I'll switch back over to take that slide off. So thank you, everyone, for watching today. One thing that I will just add that I didn't mention in patents, and I think it probably applies to all these things, is that if you are looking at taking your business internationally, then you should think about how you're going to protect your intellectual property overseas. So in Australia, if you're going to or want to apply for a patent and move that business overseas, you can actually apply for patents in other countries. You've got 30 months to do that. Australia has a patent cooperation treaty with some 150 odd countries. And what you can actually do is if you do it within the 30 months of when you actually apply for the patent in Australia, you can look at getting it registered in those other countries. Now, that's important from as we're an increasingly globalized world, the registration of patents in other countries can actually be a great asset to you and build up a business. So you can do that with trademarks as well. I'm actually not sure, Craig. Do you know if you can do that with registered designs and the other ones that you talked about?
Yeah, there is. There are international design registrations as well. And during the process, if you need to have it registered internationally, then you can do that. Or consultants will let you know when to do it and how to do it and those sorts of things. But definitely there's international rights as well.
So obviously there's a cost to that as well, isn't there? So people need to be aware of that and make sure that when you are getting advice on the registration, especially international registration, that you find out what the fees are, what the registration fees are, and make sure that they're converted into Australian dollars. As we know, the Australian dollar goes up and down like a yo-yo sometimes. So if you're applying for America, you want to make sure that the fees that you're paying, you understand what they are in Australian dollars, so that you're not paying exorbitant fees for a registration in the US.
Yeah, for sure.
Excellent. All right. Well, as I said earlier, this is today we're recording this on the 27th of September. So this is the last day that we're doing intellectual property. Next month, and starting with Fast 6 Monday on October the 2nd, which is a public holiday in Brisbane, but we'll still be here doing our live TV show. Is hopefully with the Cowboys having been successful with the NRL Grand Final the night before. But we'll be back to do phase 1, which is conception. So that's all about the beginning, even before you start a business. So in August we did phase 2 startup. Phase 1 is about conception. So this is about when you've got the idea for the business and what the information and what you need to do before you actually even start the business. So we'll be back with Fast Fix Monday. Fast Fix Monday on Monday, the 2nd of October. Craig, anything else you want to add before we say farewell to everyone from Intellectual Property Month?
I don't think so. Thanks for joining us throughout the month, and hopefully next month we can give you some more information about conception. Looking forward to Monday. Fast Fix.
And as always, if you do have any questions, feel free to message us. You can message us on the on the Facebook Live feed if you're watching it through Facebook Live. If you're watching it through YouTube, send us a message. Our email address comes up down the bottom on the tickers, so we're happy to answer questions and happy to help out where we can. So thanks for now, and we'll see you on Monday.
See you Monday. Thank you.